Okay, it is. It is that time. It is Wednesday. It is noon on the East Coast. It's 9 a.m. on the West Coast, where our guest Gene Takagi is, and I'm going to get into introductions of everybody here on the screen here in just a minute. But welcome to our Board Source live stream. We are really excited to have you here. We last week we had a great conversation between Ann Walstead and Board Source Board Chair Kathy Trower, and we're looking to a great conversation today with our guest Gene. And when we started having conversations about what we needed to be talking about here, we were really thinking back to our Ask the Expert service and the questions that you've been asking, and folks have wanted to know since this COVID crisis really kind of enveloped all of our lives and our organizations. And we knew this was coming for a while, but I don't think anybody really understood the severity or how our lives and daily organizational operations would change until they did drastically 2 or 3 weeks ago now. So when we started getting a lot of questions from you around questions about bylaws and how to have meetings and how to stay within the law of your organization, we thought that Gene would be a wonderful guest to have. And Gene is the principal at NEO Law Group. He's also a contributing publisher of the nonprofit Law Blog, and he is a lecturer at Columbia University. And last but not least, Gene is also a new Board Source board member. So, Gene, thank you so much. Gene is in the top left-hand corner of your screen, and he really will be the centerpiece of today's conversation. And we're going to be having a lot of legal questions. And I think, in this setting, I'll let Gene kind of give his own just to outline where he can and can't give kind of exact advice. But last week when we had a pre-call to discuss what was on the what we were going to talk about today, our discussion today, I went straight to him and said, "Is there anything you're not comfortable discussing?" And his response was, "Not really." Gene we've talked about a ton of different items that we want to get to. So with that being said, also want to introduce to you once again, same as last week, Ann Walstead is here. She is the president and CEO at Board Source. So without further ado, Gene, I know when we had a conversation about things that we've been asked and what you're hearing throughout the sector, but the first thing I would love to just hear from you is, what from your kind of your expert opinion are people not talking about that maybe they should be? What might be flying under the radar before we get into all the questions that they do have that you want to just say, hey, let's make sure we're thinking about all of these issues or certain issues as well as the other things that you're worried about?
Thanks so much for teeing that up, Andy, and really honored and delighted to be here in these difficult times, just to be able to share some information with everybody. And having come from a management background before I became a lawyer about 20 years ago, I forget about some of those caveats. So yes, just echoing you, Andy, I can't provide legal advice to your specific situation. I'm not an employment lawyer or an intellectual property lawyer, real estate lawyer, but I kind of have a viewpoint on almost everything, which is why I'm a little bit open to talking about anything and answering questions from my perspective and my opinion. And one of those things is just sort of covering areas that maybe not everybody else is covering, but should be thinking about as boards and leaders of organizations try to deal with the current crisis and what that means. And so some of the first things that I wanted to talk about were, the first thing that would come to my mind as a leader of an organization is safety. And that's safety for the beneficiaries that we're serving, that's safety for our employees, that's safety for other stakeholders that might be using our facilities or our services or programs, physical safety, emotional safety, mental safety, a lot of things to really think about. And so from a legal perspective, I would say, well, there are some laws that are generally involved. Now, the OSHA is kind of the sort of the Occupational Safety and Health Act that most people are aware of dealing with workplace safety. And there is a general duty clause there that requires employers to furnish to each worker employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm. And we certainly know that the coronavirus and COVID-19 are serious dangers and there are risks, which is why many of us are having shelter-in-place laws. applicable to our local areas or even to our states, and why employers have to think about this as well, to the extent that they are operating and still in operation, or even to some extent, if they have employees working from home or working from other facilities and areas. Now, if they're doing purely administrative work on the computer, probably not too many OSHA dangers there. But if they're doing more than that, if you're asking them to meet with people, obviously that creates some risks. And that's just one area for people to really think about and plan. So boards, if you don't have um, a policy or plan in place for ensuring that your employees and anybody else who's interacting with your organization are working under safe conditions and in a safe environment, that's something to really you know think about. I've heard of issues of like um, university employees that might not have access to the internet at home and so can't follow the same workplace rules, being told to drive by campuses where they have Wi-Fi and work from their car. And I'm not sure if that's the best solution for many organizations, but there are some creative solutions being out there. But you do have to think about, again, employee safety, and to the extent that you codify that as rules or guidelines for your employees to follow. I think that's a really important point. I'll just see if if Anne might have any thoughts about that as well.
No, I just totally agree. And as we talked about last week, thinking about the safety and well-being of your employees and the people that you serve has to be the starting point in terms of how boards and executives are thinking about contingency planning. And depending on where folks are in the country, that may be, in some ways in the rearview mirror with plans already in place. But for many organizations, they're just facing and grappling with this. So I couldn't agree more in terms of the importance of starting there.
Great.
I just want to remind everybody, feel free to check in on the right-hand side. Let us know where you're watching from. Let us know. We definitely want those questions. We're going to definitely be taking your questions from that comment section. But just drop a comment and let us know who you are and who you're with. We're really excited about having you on the line. Another thing that we had talked about, Gene, was, and it's something that I think a lot of organizations are dealing with. I know BoardSource dealt with this. We had to make the difficult decision, but obvious decision to cancel our conference. And when events get canceled and you have third-party vendors and you have contracts all over the place, can we talk just a little bit about, because this was a huge thing that we got questions about in our Ask the Expert service, but can we talk about breach of contract for just a second? And both as a service provider, but also for those organizations who may have been providing services that could no longer go on.
Yeah, thank you for teeing that up, Andy, because, a lot of people who were dealing with events and possible event cancellations were certainly looking at contracts and something called force majeure clauses. And force majeure clauses are generally provisions that allow a party to excuse their performance without that constituting a breach of that agreement. Some people describe force majeure as an act of God, and they're thought of in sort of the traditional disaster context, like hurricanes and earthquakes. And about 10 years ago or so, or actually around 9/11, then we started to think about acts of terrorism causing also a force majeure clause to come into play. Not a lot of sort of contractual language that I've seen that talk about viruses or pandemics as being a force majeure reason. Although as we think about it now, certainly we're going to be thinking about that in the future. And everybody's going to respond to this the same way they responded to terrorist acts after 9/11. But with existing contracts, you have to think about what's included in there, if there is even a force majeure provision that allows you to say, we can't perform this contract and we want to terminate it based on that, without any party constituting this as a breach of contract. And for organizations that had events, this was a saving grace to help them not be on the hook for all of the payment obligations that they might have had with respect to an event, if the force majeure clause included something that allowed it to be come into play. But for others, it may not. And that's something you have to take a look at with respect to individual contracts. And now, as organizations start to think about this, we're a few weeks in now, is to go back into their contracts and say it's not just event contracts; it's all of our contracts that we have to think about. Can we, if we don't have people at work, can we actually perform the contract? Can we perform our grant agreements? Can we perform our agency agreements with different governmental agencies? Can we perform our services for our corporate sponsorships? So we've got all of these agreements to look at. Now we have to say, do we have a force majeure clause at all in there? And if so, does it even apply in this situation? So this is maybe a tip for future contracts as we're looking into. But as we think about force majeure in some jurisdictions, including New York, you have to think about whether you've actually identified specific types of acts that would constitute force majeure, because the courts are not likely to broaden it. If force majeure isn't descriptive of a viral pandemic, it might not actually come into play, even if you have a force majeure clause in there. But work with other parties, because contracts are not just legal instruments. They are signs and indicators of a relationship created by mutual assent of the parties. That's the whole purpose behind it. And so when you do have a contract with another organization and you're not able to perform it, this might be a lease as well. Talk to the other party. And I think you'll find there are a lot of understanding people, and there are a lot of other persons and nonprofits and for-profits that are in the same boat of not being able to perform a contract. The other side of the equation is when you're owed the money for performance that you've already given. And you've got to see yourself on the other side of that coin as well, that the other organization might be able to claim force majeure, or the other side might just not have the funds to be able to pay you. What are you prepared for at that time in terms of negotiations, in terms of remembering long-term relationships and what you want to do to preserve those relationships? How key are they, or do you really need every last dollar right now? And couldn't you even get it? Or are you just going to force them to say, we're insolvent, we're going to go bankrupt, we're not paying anybody? So lots of things to think about in contracts. But force majeure is one of those things, one of those provisions to think about. Under equity principles, if you ever end up in a lawsuit, which you don't want to really go through at this point, I don't know how quickly the courts are going to be able to take you. Impossibility, impracticability, frustration of purposes, those are other things you might Google and speak to your lawyer about as possible ways to avoid a breach of contract claim against you if you're unable to perform.
Thanks for, I mean, that really provides some clarity. Another place, speaking of being able to pay, a lot of organizations are dealing with access to resources and being able to pay obligations right now. So I just want to make sure that we talk about an organization's ability to tap into things like their endowment or a quasi-endowment. And can we talk about spending restrictions under MIFA, and why the threshold for presumptively imprudent spending may be rebuttable right now?
Yeah, so thanks, Andy. Two huge issues that I think are worth spending some time on as well. And the first is for those organizations who are lucky enough to have an endowment, and I understand that I would say most organizations don't have that luxury. So there are reserve funds that other people are looking at. But one of the important things for those that have the luxury of having an endowment is to know, is it really an endowment subject to endowment laws, including spending restrictions? Or is it not truly an endowment under legal terminology, under the legal definition? And so if the donor created the restriction, or the organization solicited something specifically for an endowment, that's kind of the true endowment, where all of the endowment rules will apply, including certain spending restrictions, which may make it a little bit tougher to draw out as much as you may want from an endowment fund. But often organizations refer to an endowment as something that the board created to save for a rainy day and maybe not spend and try to just live on the income from that specific fund. But if the board created that restriction and the board called it an endowment and not the donor, well, then that's not a true endowment. And the board can actually change its mind by board action, take a resolution, and take off that board created restriction and deploy as much of the quasi endowment, as it's often called, as it wants, because it's not a true endowment, not subject to the spending restrictions. And the board can access those funds. So if you've got an endowment fund or something called an endowment fund, check to see whether it's a true endowment or not. And if it's not a true endowment, consider whether you want to deploy some of those resources now, maybe more than you ordinarily would, because as many people call it, if this isn't a rainy day, I don't know what is. So that's kind of one thing. I do have a special note to funders out there that I want to talk about as well, and that's with respect to their endowments. And so I mentioned spending restrictions that are attached to true endowments. And under UPMIFA, which is this crazy acronym that lawyers and accountants like to use, but it's the Uniform Prudent Management of Institutional Funds Act. And it applies to both endowments and other funds, like reserve funds that a nonprofit might have for charitable purposes. But the spending restriction applies just to the endowment funds, those true endowment funds. And if you spend more than a certain percentage of the net assets held in the true endowment, then that can be seen as imprudent. And some state laws will actually say, if you've got a certain percentage, in California it happens to be 7%, if you spend more than 7% of your endowment's net assets in any given year, that is presumptively imprudent, which could mean that you're subject to a penalty and the board members could be breaching their fiduciary duties for going beyond that. Now, funders may rely upon that to say, we can't spend more than this. And someone may say, we're going to spend our 5% to meet the IRS spending rules for private foundations, and that's it. We're not going to go beyond that because we don't want to violate those UPMIFA laws that have those spending restrictions. Well, the state laws may say it's presumptively imprudent, meaning that that presumption can be rebutted. And again, that's saying, if this isn't a time when you can't rebut a presumption like that, especially if it's to save your organization, what good does it do if you've got these assets that are tied up in an endowment fund that you can't access, as you have to lay everybody off and kill all your programs now? That's not kind of something you want to say, we couldn't do any more because we couldn't spend more than our 5% or 7%. So that's just a quick message to funders out there to think about that. Talk with your lawyers who understand UPMIFA. So if you're using a pro bono lawyer, make sure they understand UPMIFA before you take their advice, and think about what you might want to spend and the reasons for possibly looking to rebut that presumption. I'm hoping state regulators actually put some guidance in there that give a little bit more comfort to funders who want to consider rebutting that presumption this year as well.
Gene Bell commented.
And what I'm hearing within that, Gene, too, is, and across some of the different topics that you talked about already, is don't assume that this isn't an extraordinary moment, and engage, whether it's with, sort of partners within contracts or talking with attorneys about interpretation of this moment. Don't just accept what is, think about what, makes sense in this moment, in this context. And I would just add to that, kind of in a macro way, advocacy as the lever for, impacting what should be instead of what is a really important tool right now. Not specifically a legal question, but something that I know you are equally passionate about, and the importance of nonprofits really engaging with lawmakers about what makes sense in this moment, whether directly or through a coalition that's advocating on your behalf.
Yeah, a couple of things. Just Gene Bell just commented the things that we learn, or the new language that we learn during times like this, and I have to just echo that comment because UPMIFA is certainly new to me. We had a comment earlier that I this was just a comment of positional situation that Dave is in, and he noted that he's a CEO of a homeless shelter that is an 80-bed shelter, and they were heeded to OSHA general duty clause to reduce their shelter population by placing 50% in hotels at the agency's expense, which leads me to more questions about accessing funds and a question that I have, or one that I definitely wanted to lift up here, is the ability or guidelines for using capital campaign funds for operating expenses in a time like this.
Great question, Andy. So, to the extent that the capital campaign funds were restricted by the donors, that restriction still exists. And you'll have to go to your donors again. And again, I'm hoping that most donors are going to be understanding of the situation and say, yes, we definitely release the restriction here. It's not the best time in the world to put up a new facility when your old or your existing facility may go under if we don't have access to those funds. So definitely talk to your donors about that. If your donors created that restriction for the capital contribution, that's what you should do. You shouldn't just say we're not going to pay attention to the donors' wishes and go forward. That's for legal and PR reasons. You don't want to do that. Donor public relations, it's really important to make sure you preserve the trust that they have, even in extraordinary times. If, however, just like with the quasi-endowment I mentioned earlier, if the capital campaign fund were funds that were put in there or designated as capital funds by the board, those aren't truly restricted funds. Those are board restricted funds, and that means you should treat them as unrestricted. You can use that for your ordinary operations.
So Dave had a question, kind of a follow-up to that last question, but what constitutes legal documentation to release a restriction on a grant, i.e. a foundation provides an agency with an email lifting restrictions due to COVID-19. Is that sufficient?
There's strict legal compliance, and then there's kind of the rationale of why we have laws, right? And strict legal compliance might say, you know what, just to make sure all of our T's are crossed and I's are dotted, that let's have this formal contract, let's make sure there's a wedding signature on it, and let's formalize it in as much detail as possible so there's no possible misunderstanding in the future. I'm not giving legal advice again, but if you've got an email and it's coming from an officer that you can rely upon that has the authority to release that restriction, I would say that you're pretty safe in relying upon it, as long as you know that email isn't coming from a Gmail account or a public account that might be spoofed by somebody, but is actually coming from the organizational, let's say the CEO or executive director, and they're giving that release. I would feel comfortable about it. If it was a program director and it's your program director, it may depend upon the relationship that you have with that individual and what that person's position is within the organization. If they're in a hierarchical organization where they're kind of several rows down the ladder, you might want to question, especially if the grant is very big, whether they have the authority to do so, and you might politely say, thank you so much for releasing the restriction. Would you mind copying or getting your executive director or the head of the grants management to sort of just confirm that this is the case, so we can rely upon it, and blame the lawyers, blame me for saying.
That's exactly what I was going to say. It can be helpful in those moments to say, I'm sorry to ask, our accountants or our attorneys are asking for additional documentation.
Yeah, so let's just shift the conversation, staying kind of on the same topic, but a similar conversation here. If you had a donor who had given restricted funds for a capital campaign, let's say, could the organization create a document to send to donors asking them to release their donation for general funds?
Yes, you can. And don't make it a 10-page contract, right? So make it one paragraph, and short, and be super thankful about it. It can be informal, but do ask for the donor to be able to accept that. Even the IRS now is taking, this is unusual, but this just came out a few days ago. The IRS is now taking email and electronic signatures now because of this crisis, and not wanting to have people meet in person to get wet ink signatures. So make it easy for the donor to be able to release that restriction, but ensure that it actually is coming from the donor. So if you use electronic means, you do want to make sure you have a little bit of extra assurance that your donor is providing that communication and that release. Ideally, it would be a scanned letter, again, that you might give them the form for, and you might just say, just sign here and send us an email copy scanned back. But if your donors are maybe a little weak on the technology front, like me, that might be a little bit harder. So even getting them to respond that way. If it's a phone call, I feel a little bit less comfortable with that, but you might ask if you can record it and keep it if you're sure that that's the donor. But again, little evidence and common sense rules, right? If it's $1,000, a phone call is probably fine. If it's $1 million, probably, a signature and a scanned copy back.
Yeah, so I want to get into voting and meetings here in just a second, because by far those are the questions we're getting the most about through our Ask the Expert. And by the way, just for anybody who's on the line, I love that you're asking all these great questions. Keep them coming. If we don't get to them here necessarily, we will try to answer them on our COVID-19 response page on our website, where we are answering Ask the Expert questions every single day and posting those to our website. So we're trying to get 3 or 4 of our most common questions up there. But if we see something up here that for some reason doesn't get answered today, we'll try to tackle those in our Ask the Expert on their COVID-19 response page. But before we get into this is another question I have, and this comes from Marty Martin, who is a friend of BoardSource, is an attorney down in Raleigh, North Carolina. I have a feeling Marty has an opinion and thoughts about this, but I'm assuming he's getting this question a lot as well, which I think a lot of attorneys are. Should the board use independent counsel or rely upon advice from an attorney who may be serving on their?
It's a great question. I'm always scared about questions from other lawyers, because we are good at finding the nuances, and it's very hard to answer generally for everyone. But here's kind of where I see things. If you can get independent counsel, and again, if you have the luxury of being able to afford independent counsel, get independent counsel. I know now you've got competing costs, though. So if you get independent counsel, that may mean that you're not getting something else that also is important to you. So you've got to weigh out the benefits of that. You've got a board member who happens to be a lawyer, or somebody close by, an advisory board member who happens to be a lawyer. If the question that you have as a board is within the practice areas of the lawyer that you're asking, and they're very comfortable giving you a response to that that's simple, even if they say, as lawyers must say, if they're giving advice to clients or information to clients, that this isn't legal advice, as I had given before to your prompt, Andy. That's often good enough, right? So if it's a question where there's not going to be significant harm done to the organization based on what the lawyer is telling you, and that it's within that lawyer's volunteer board member's area of expertise, I wouldn't lose sleep at night over following that advice. And that lawyer will probably be able to sort of give you the nudge, nudge, wink, wink. I'm pretty comfortable with this area of law, and generally speaking, this is what I think. But if you've got a difficult area, if you've got a contractual provision where if you mess up, it might be a real big hit to an organization who can't afford big hits right now, to the extent that you can get an independent counsel to weigh in on it. And again, different organizations are different positions to be able to access independent counsel. And there are not a lot of people in this nonprofit law area that we practice in. They're depending upon what type of advice you're looking for, you know, try to get it if it's super important or could do substantial harm if you got the wrong advice.
Great.
Yeah,
Okay.
and I would just add to that, Andy, a lot of the questions that I know we're getting from folks are really detailed questions about employment law. And getting advice from somebody who doesn't have employment law expertise on a complex employment issue is definitely, at least from my perspective, not as an attorney, one of those things that would qualify for Jean's advice of making sure that you're getting somebody who's really expert and can give you advice.
1,000%.
Yeah, I think that's just great advice. It's not that you just we're getting a lot of questions about this, and it's not that we don't want to help and we want to be able to do the best we can, but there's just some areas where we want to make sure that you're protected. So we just can't answer some of these questions. Let's jump into this area about virtual meetings and bylaws and voting virtually. There's so many questions that we've gotten, particularly from membership organizations around annual meetings and what happens if they have to move their annual meeting, even when it's set in their bylaws that it takes place at a certain time, or they are moving virtually and they've never had meetings where they voted virtually before. Can you just give us kind of the overview here of the things that you should care about, and I'm particularly interested if it's better to be out of compliance with your bylaws, or should the organization focus on changing those bylaws? What's just some of your general thoughts here?
They're great questions, and so there are a few caveats here because there's a lot of state law variation. And then there's also organizational variation because where the laws prescribe that something be done in a particular way, the bylaws can be drafted so that the organization can customize exactly how they're going to do things. So now the question is strict compliance with the bylaws or strict compliance with the state law? Like, do you have to worry about both of those things, even in times of even in extraordinary times, like this. And again, the letter of the law might suggest, well, if your bylaws don't anticipate or your state law doesn't anticipate things like emergencies, where it would be obviously completely foolish to have an in-person meeting of 200 people in a room. If your bylaws require that, that's just something that board members with their fiduciary duties have to think, the lesser of two evils is to not comply with the letter of our bylaws out of public safety, which is the first thing we talked about, right? The public safety and the safety of your employees and of your members. That's the preeminent concern here at a time like this. So yes, think about how to comply. But if there's overweighing concerns, you're going to have to think about coming out of compliance and trying to come back into compliance or as close to compliance as possible using good faith. And what that might be is reaching out to your audience or to your members, in this case, electronically or virtually. Even if it's not at a formal meeting, to let them know under these extraordinary circumstances, we plan to, reschedule our meeting to a date once we have more information about how this crisis is playing out. I don't think anybody can really promise that, on June 1st, we're going to have it because we'll be done. I don't think that's realistic, and you do have to sort of worry about your notice provisions in the bylaws. The reason why the letter of the bylaws can be a little bit troublesome when you have voting membership organizations, is that a single member can raise an objection based on a technical deficiency and call into question whether the action taken at that meeting is valid or not. So even if there was a 99% vote in favor of doing something, but it didn't comply quite to the letter of the bylaws, you have that one dissenting member who could take an action. If that person is litigious, they can just create all sorts of administrative burdens and headaches. So you want to address this tactfully when you know you're not going to be able to comply, and try to make sure that there's a little bit of peer pressure, if you will, to make sure that every member is working in furtherance of the common goals of the organization. That, remember, our mission and values come first, and compliance is ordinarily part of it, but there is this overriding concern right now of safety, and that's why we're going to come off of it a little bit.
Gene,
for virtual meetings, there's often, these are state law issues, and often there's not very much mentioned about virtual meetings. Oftentimes they're referred to just as electronic transmission to and from the corporation, which is hard to think about in that way. But if you want to come a little bit closer compliance, remember you only need a quorum. This is true for board meetings as well, right? When not every board member or every member who's going to vote that ordinarily might come to a meeting, and you want to get as high in attendance as possible. These are times where you're going to have to think about just getting a quorum may sometimes be enough, and membership organizations often struggle with getting quorums. This might apply more to board meetings, but if you talk about things over email, even though that doesn't constitute a meeting, you can have discussions, or over Slack or other virtual channels where people can communicate maybe asynchronously, not at the same time, so it doesn't count as a valid meeting, but you can have a discussion so you know how to act. And if boards aren't meeting or discussing now, I understand everybody has their own personal concerns, but organizations need you right now. This is the time for boards. If you haven't met in the last 2 months, you've got to hold something very, very quickly to address these circumstances. And if you can discuss it with everybody having an opportunity to weigh in, and then getting the meeting done later with just a quorum, where you ordinarily might get 90%, but here you might only get 51%, if that's what a quorum is, that's okay. And that same idea for members as well. If you allow members to weigh in and say, we're not going to have our meeting on April 30th, but we want your feedback on these issues, because these are the things that we were going to address at the meeting. We will weigh it all in right now, and we will hold that meeting as soon as possible.
Anne, did you hear Gene say a minute ago that you might have a board member that could be a problem? I don't think anybody on this webinar has ever experienced a board meeting where there was one board member who wanted to challenge decisions. And
No, never.
never would happen. And Marty Martin had a great kind of follow up to this. Was the question in that first part of your answer is who may have standing to challenge if the board is out of compliance in the letter of the law versus endeavoring to comply in good faith given our circumstances, really.
So again, some state law variations here may be out there, but my understanding is, and this would be true in California, and I think probably almost all states, would be that any voting member, that is a member who traditionally has the right to vote on an election of directors, or vote on major corporate changes like a merger or dissolution, that type of voting member has standing to sue board members for breaching their fiduciary duties, so could challenge a board action as invalid if they really wanted to. So for large membership organizations, the possibility of having a member, not even a board member, but just a member, if you have like 1,000 members and one member is out there who's litigious and really adamant about challenging an action based on this, they could create trouble. I think from equitable principles, a court might not see things the same way, especially if there was some outreach done to solicit opinions, and there was this overwhelming vote that didn't go that person's way, especially at a time like this. But yeah, there is the potential for trouble.
I do.
Gene, how much does it help, if at all, to separate voting into a vote on process and then a vote on the matter at hand, so that essentially you're asking people to vote to have a different approach to voting and then a vote on the matter at hand. Does that help at all?
It might, although sometimes if the process is codified in the bylaws already, you have to vote to amend the bylaws, and that might create some more restrictions, as there are certain rules that the organization might have or the state might have about amending bylaws. So it gets a little bit more complicated. It really is organizational specific, so it's tough to give, guidance there. But for organizations to really look at it carefully and try to be in tune with their members. For anybody thinking about creating a startup, having voting members is really a complicated and very heavy administrative burden. So be careful while you create, in some ways, a little bit more ownership, if you will, into an organization. If you have a vote with respect to it, it does create that challenge, especially if you've got that dissenting board member issue or dissenting member issue.
Thank you.
A couple of things, and just maybe really quickly, it would seem to me, if you were going to be outside of your compliance, to maybe codify that, or to write that down and attach it to the notes to record what changes you may have made to be out of your bylaws, and then attach that into minutes, or are you opening yourself up to more liability by doing that?
I think it depends. But if you want to fudge it a little bit and you don't think it's going to hurt and nobody complains about it, what you may want to do is ratify it at the next meeting. So it gets the formal action in the right way to cure it later on. So it might not have been done perfectly at the time, but it's cured later on. I would often use that. So you record something so you know that at the next meeting you actually want to ratify it.
Thanks. So we're about 40 minutes into, so we've got about 20 minutes left here, and I want to make sure that we cover really big issues, and folks are starting to mention these and talk about these in the comments. And I'll just read Darlene's comment here, and folks have replied to her, but let's start having this conversation and kind of get in here. But Darlene was asking, is everyone aware that the CARES Act employee relief portion applies to nonprofits also? If you have employees, it could likely be a huge help. She's researching and consulting with CPA and tax attorney friends now. And I also want to make sure, while we kind of get into the CARES Act, also talking about kind of the other act that was passed last week or the week before around employee leave and employer tax credit protection as well. So we can just start with general kind of observations, Gene, and where you think organizations should be paying close attention, and then we can get into some more specific questions.
Yeah, terrific. And we definitely wanted to talk about the CARES Act and the earlier Families First Coronavirus Response Act, which is where the leaves were. And so let me talk about the Leave Act first. And yes, oftentimes the who qualifies to sort of get the benefits of this were referred to as small businesses, and it's managed by the Small Business Administration. And so nonprofits might think ordinarily, oh, the SBA doesn't really talk about us at all. But here, and calling back to Anne's point about advocacy, if there weren't these anchor organizations advocating for nonprofits to Congress, we may have never seen these nonprofit added provisions, or we might have seen some exceptions that would take out certain nonprofits from benefiting from this, thanks to the really hard work by just calling out a few, like the National Council of Nonprofits has got some excellent materials. They've done some excellent advocacy. State nonprofit associations, independent sector, board source. There are council and foundations. There's some real organizations here that are doing advocacy work to make sure that nonprofits are seen by Congress and not overviewed. And when you're dealing with $2 trillion of where money is going, if you don't have nonprofits in the equation, that is a huge problem. So for every smaller, medium-sized nonprofit, think about joining state associations. Think about joining their advocacy on these issues, because it's really important. But let me get to the main issues of the two acts. The Leave Act, 2 weeks of emergency paid sick leave. Okay, this is required of all small businesses and nonprofits with under 500 employees. If you are under 50 employees, because paid leave obviously costs money that you may not be making anymore, so it could be hard. But if you are under 50 employees, you may be able to make a case of undue hardship and not comply with these leave benefits. But to the extent that you can, you should. So 2 weeks of emergency paid sick leave. It's up to the employee's regular rate, up to $511 per day if the employee themselves is out because of their own status, and that could be because of sick leave or due to the COVID-19 issue, or to seek a preventative care for that, or subject to a quarantine, as many of us are now. If it's to take care of a child or other family member, then it's 2/3 of the employee's regular rate, up to $200 per day. So that's 2 weeks of emergency paid sick leave. These provisions get very, very complicated. So I'm going to shout out to the Council of Nonprofits, the National Council of Nonprofits, that has got several resources up there, and they did a webinar yesterday specifically on these two acts that are really well worth looking at for the details. And note that all of us are talking based on statutes. It was close to 900 pages, and there's no regulations and there's no state law yet. So we're still very in the very early stages of what type of relief and how it's going to look. But that's the first 2 weeks. Then there's 12 weeks, which actually works out to being an additional 10 weeks of emergency family and medical leave. That gives you another 10 weeks of protection there. And for family related care, again, up to 2/3 of an employee's usual pay, up to $200 per day though. So when it's caring for a family, it's $200. When it was for yourself, it was $511. The cap on that is $10,000. The important thing for nonprofits here is going to pay this leave, and then you're going to get a credit back for it. So that's the thing that we really needed to see. So the employer paying for the mandated paid leave is entitled to claim a refundable tax credit in that amount. So that's the leave law, not part of the CARES Act, which is kind of doing with the small business loan, forgivable loan things that we'll talk about next. But let me pause there to see if any of you have anything to add.
Well, Anne, I would love to
get just a helpful overview of what that means, for our employees, and what that legislation does for them, and then what that means in terms of organizational leadership, board and executives together in terms of what's available from a credit perspective, so that can help offset. Thank you.
Yeah. Just a note here. BoardSource in the comments has just shared a link to the webinar that Jean just mentioned from our friends at the National Council of Nonprofits. Also, Julie shared a link around a chart that shows what the CARES Act provides and what loans are available for nonprofits in the CARES Act. And I know Jean's going to talk more about the CARES Act now, but I just wanted you to be able to see those resources, save them, bookmark them, be able to come back and look at them when we are finished here today. So, Jean, back to the CARES Act.
Yeah, so the CARES Act has some really good news for nonprofits in their ability to participate in something called the Paycheck Protection Program. And that's, again, applicable to small businesses and 501c3 and I believe 501c19 veterans organizations with under 500 employees. And the language in the bill says where current economic uncertainty makes the loan necessary to support your ongoing operations. So it really is important to look at the broad, how broadly that encompasses, I would say, nonprofit organizations and your ability to access it. There's $349 billion that's budgeted for this. So my first suggestion is that I believe the application is going to be available Friday. There's already samples out there, but I believe this is a go on Friday. And to go in early is my best suggestion. Because if the funds run out, and you've got, again, every small business, not just nonprofits, but every small business out there in the country, 47% of, I think, of our population is hired by these small businesses, eligible to receive this loan. I'm not sure that $349 billion is enough to give everybody, because you can access quite a bit of money here to sort of incentivize keeping employees, which is the idea and why it's called paycheck protection. So generally, the loans are going to cover payroll costs, which includes benefits, but up to $100,000 in annual income per employee. And it's also going to include rent, mortgage payments, utilities, under lease agreements that were in place before, so not for brand new ones that you're going to get into. And eligible recipients can qualify for a loan of up to $10 million. So for some of the larger small businesses, it's quite a bit. But how do you determine how much you're going to get? Well, it's basically 2.5 times your monthly average payroll costs. So they're going to take a look at a test period of the last year, and 2.5 times that monthly payroll cost is the amount that you're going to be eligible for to get a loan for. The loan payments, if you're going to have to make them, the interest rate is set right now at 0.5%, so very low. It has a cap at 4%, so it's possible to go higher. And technically, that loan is due in 2 years, although it can be extended as well. But the sweet part of the whole payment protection program is that if you apply for these loans for nonprofits, you want to get them forgiven, turning those loans essentially into grants. So you never have to pay that back. So 2.5 times your monthly payroll cost. The idea is it's going to give you 10 weeks of cushion due to this coronavirus, where your income's probably been substantially impacted. So you don't have to lay these people off, your employees off. If you do end up laying people off during this period, after you've taken this loan, the amount that will be forgiven may be adjusted. So if you laid off 25% of your workforce, well, then you may not be forgiven for the whole portion of that loan. It may be 75% of the loan that's forgiven. So there's going to be some pro rata formulations there, and the administrative rules are going to follow. No collateral, no personal guarantee. So this is not like an ordinary loan. I think Treasury is working now to make sure that every FDIC insured bank can provide this to you, but there are SBA, Small Business Administration lenders out there besides the banks that can give it to you. They want to make sure that there's going to be a flood, right? As soon as this becomes available, there's going to be a flood. So again, even though your staff is working, many of you, to the extent that you are working out there, you're probably really got everybody burdened, operating at full capacity. But make this a priority. This is 2.5 months worth of income that you can get that's effectively going to be a grant. So make sure you're paying attention to this and apply early. The application is going to be fairly streamlined. You're going to have to provide some basic information. There is a form out there. I don't think it's the actual application yet, but it shows you what it's going to look like. It's pretty basic, but there may be some supporting documentation you need to have, including how many FTEs or full-time employees you have, and how many, what your payroll is, so that 2.5 times calculation can be done. So make sure you're starting to look at that now, gather your materials, and if it becomes available Friday, start to think about applying early. It's going to be available for application until June 30th. So don't wait till June 25th, because the money may have been depleted. We don't know if there's going to be another increase in the budget to make sure everybody gets a chance at this. So let me pause there. That's the big one.
Sorry, Jane, I didn't mean to trample on your words. I just wanted to add that we are monitoring this and watching for it, and as soon as the application becomes available, we'll be pushing it out, via our network. So we'll help you look for it. But totally agree with what you're saying, Jean. This is just too important an opportunity to provide resources to organizations at a critical moment to waste it. So find the time.
Yeah, Sarah Brown Werder here in the comments has linked to the treasury.gov page where the application is up, it looks like. So we will share that. I don't want to click on it now because that will take you away from our screen, I believe. So but if you're interested, Sarah has got a link to it there. And other folks had really an interesting conversation on that side as well about lender preparedness and talking with your specific lender about when they'll be ready to start kind of processing these requests. I do have a couple of really quick questions, Jean. We had gotten about PPP around part-time employees versus full-time employees. Is there any difference? And same question for independent contractors.
So there are different ways to look at the employee, how you count employees, and one is for whether you qualify as a small business or small nonprofit for these purposes. So the 500 employees includes that threshold includes both full-time and part-time employees. The compensation, or the 2.5 times payroll, will apply to both full-time and part-time employees. So you're looking at everybody for calculating that payroll cost for which you can get that loan that will hopefully be forgivable. But independent contractors, at least to my knowledge, are not included in that calculation. So independent contractors who are small businesses can apply for this payroll protection program themselves, and their own salaries may be able to be counted as well in it. So they may have separate protection that way. But for the nonprofit that's hiring an independent contractor, they don't get that benefit. And actually that raises a point that's important here. Nonprofits out there, if you're employers, be very, very careful. If you're terminating or laying off an employee and rehiring them as an independent contractor, and they're doing the same thing, that's not permissible. You could get into a lot of trouble for not withholding proper payroll taxes, misclassifying employees as independent contractors. A lot of people think about doing that because there's some cost savings just having an independent contractor who doesn't get benefits, who doesn't, you don't have to put in employer portions of Social Security and Medicare tax. But you really can't do that. That's something definitely talk to a lawyer about before you're even thinking about doing that.
We've only got a couple of minutes here, but I do want to get to a couple of questions. Can you talk briefly, Shyam had this question, can you talk a little bit about the change to the charitable deduction for 2020?
Yeah, real quickly, there's going to be an increase for itemized filers. That's moving up from 50 or 60% of AGI limitations, essentially meaning that if you made, just using round numbers, $100,000 in adjusted gross income, before your cap for a cash contribution would be 60% if you're giving to a public charity. So you could take a $60,000 deduction. Those limitations are all thrown the roof. But the more important one is the above the line, or some people call it the universal charitable deduction, which many of the anchor organizations in the country, including Boardsers, have been advocating for. And this is a $300 above the line deduction available to anybody who itemizes or doesn't itemize. And because only about 8% of taxpayers itemize now, this deduction could be important to giving incentives to others to be able to take advantage of a charitable contribution deduction. We don't know how much weight this will actually have at times when there's so much economic distress that the incentive may not be very, very high for individuals, but it really is a big help, and hopefully it's going to last more than 1 year. But for now, I think these are 1-year provisions.
Okay. It is 1 o'clock, but I want to make sure Anne and Jean just give you a little bit of time to, if there was something we didn't cover that you think, hey, this is really important that we need to get out there, or make sure. Basically, I just want to make sure that you both have an opportunity to get the last word in here. So, Ann, we'll let you go first.
I just want to thank everyone for joining us. I know you're facing tough questions, and this is not an easy time to be an organizational leader, whether you're an executive or a board member. And so please continue to let us know how we can be helpful to you, what you're facing, how we can help, what resources and guidance, tools, etc. We can provide to help make that a little bit easier and to share what others are learning and experiencing. And then just a special thanks to you, Jean, for being with us. We so appreciate your willingness to share your wisdom and expertise with folks that the folks are dealing with and struggling with, and we so appreciate you giving your time to help answer them.
Thank you so much, Anne. Thank you, Andy. I'd like to thank all the listeners as well. I do, because I'm talking at times. I do have one more provision that I really want to make sure at least I call out, and that's the economic injury disaster loans. $10 billion been allocated to that. Nonprofits with under 500 employees will qualify for that as well. And those are working capital loans up to $2 million. You can't use it for the same reason as a paycheck protection program, but it may be an alternative in some cases. The loans you actually do have to pay back. The interest rate is 0.75%, and the maximum term 30 years. So just to make sure that you're looking at that as well, and also understanding that there are higher protections of unemployment insurance available for your employees. So to the extent that you do have to lay off, despite these provisions, or possibly after these provisions fall off, if you do have to lay off, to make sure you're providing resource and guidance to your employees to the extent you can, if you're going to lay off, or help them access their unemployment benefits and COBRA insurance coverage and all the rest. So just make sure we're all caring for each other at these times. And thank you both very much.
Thank you, Gene. And just as a reminder, keep looking for Gene's nonprofit law blog, or the NEO nonprofit law blog. He is constantly putting up great information, helpful information about all of the topics we've talked about here today. I know a couple of people had questions more about if you already had a loan out, would you be eligible for some of these things? We'll try to tackle some of those on our Ask the Expert page. Next week we have, it's going to be next Thursday at noon, not next Wednesday at noon, Anthony Bug Levine from the Nonprofit Finance Fund, CEO for the Nonprofit Finance Fund, will be our guest. And we'll be talking a lot about business and continuity planning for organizations during this time. So be on the lookout for that. We will try to get you a link that will come right to this Zoom page, and we'll continue these conversations. But let us know if you have questions beforehand so we can make sure to ask those to Anthony. Gene, one more time, just brilliant. Thank you so much. Information was clear and concise and helpful, and we just are, you're a great asset for the sector, and we appreciate everything that you do for us here. And Ann, as always, thank you very much, and we'll see everybody next Thursday at noon with Anthony Bug Levine. We'll see you then, everybody. Take care. Bye-bye.
Thank you.
Thank you.